POSH Act 2013. This act came into being in 2013, but definitely such kind of situations were arising at the workplace even before 2013. The the main case which led to making of this act was definitely Vishakha versus State of Rajasthan, which is quite a renowned case, renowned, or I should say something which many people are aware of. This was a landmark judgment of the Supreme Court, which led to the birth of POSH Act 2013. But apart from that, there are several other cases which have happened and which fall under this act, and courts have ruled in the favor of complainant when such cases were lodged. Many a times it happens that people do not file complaint even though they are aware of the provisions of the act and about their rights of working in a workplace. But maybe because of social stigma, they do not report the cases and hence it goes unnoticed. However, it is being 10 years of this act, and many people are aware that if they raise this issue, their issue can get sorted, and resignation from the workplace is not the only solution to this problem. There have been many cases in past 10 to 12 years which fall under this category. There was one between Anjali Bharadwaj versus Union of India. This case majorly dealt with the issue of sexual harassment in government departments and held that all government departments must set up internal committee to address complaints of sexual harassment. There was also one more case which happened between the internal complaints committee, as internal committee was earlier being called as internal complaints committee, of TCS versus Tanuja Priya Bhatt. This was again another landmark case, and definitely a very big brand was involved in it, and the courts were very careful while deciding on this case. In this case, Bombay High Court held that an employer must provide a safe working environment free from sexual harassment, and that the employer is responsible for ensuring that the IC is constituted and functions effectively. So, the Bombay High Court definitely found some lacuna in the application of provisions of this act, and hence the case was decided in the favor of the complainant here. There is another prominent case which happened between Apparel Export Promotion Council versus AK Chopra. This happened in the year 1999. This case established that employers are liable for sexual harassment by their employees, and that they must take proactive steps to prevent, address sexual harassment at workplace. So these are just few examples of some case laws which have happened in the past on the POSH Act 2013. A very common question which comes to me from HR of the companies is generally why these case laws become important while deciding the case which has happened within their premises. So basically, why the IC members should be aware of these case laws while deciding the cases. This actually takes us to the basis of law, wherein wherein the courts have set precedents by deciding these cases, and it also helps the IC members who may or may not be legally qualified to take care of the cases. They might be experienced employees of the company, and they may be very prudent people to handle the cases, but it is not always necessary that they are from the legal background, and hence they can always take reference of these case laws to decide the cases which have come in front of them. We will discuss a few points which elaborates on the importance of case laws in case of POSH Act. In fact, why case laws are important not just for POSH Act but even other acts as well can be elaborated through these points. So first one I will say would be a precedent analysis. So through these cases basically there is a precedent which is set about and it is a legal precedent. These precedents will influence future court decisions. Analysis will show how past decisions were taken, and based on that, if there are any facts which are similar in this case, can those be applied to the current case? Is something which gets decided if the people are aware of these case laws. Other reason can be any kind of legal reasoning or argumentation which can happen between the parties. So, analyzing past cases are used to construct arguments, identify relevant legal principles, anticipate arguments. As in, your counterparty, what is it that they can come up with, and what could be a very good way of dealing with those counter arguments. Even this can be learned through case laws. They provide an insight into how courts interpret statutes, apply precedent, and weigh various factors in their decision making process. So, all these things are easily available when we really go through the case laws which have happened under POSH. And I will once again reiterate that case laws are something which are kind of ready reckoners for the people who are deciding on the matters related to POSH. So IC members should definitely be aware of these case laws. Otherwise, it might get a little difficult for them to handle the case in a most efficient manner. Also, education and training of IC members is something which is necessary. What we can call it as legal education. It becomes a kind of compulsory thing when it comes to IC members who are going to handle these complaints. It helps to analyze case laws. So, what exactly happened in a previous case law? Say, if, for example, if we take Vishakha versus state of Rajasthan, if we try and understand what were the facts of the case, what was the kind of injustice which was done to the woman, what is it that the courts did about it, and what are the final decisions which were taken by the court on this.